to the final edition of the Profession webinar series on professional development and career guidance organized by Pro Studies of Sri Lanka Law College in collaboration with the lead generation of Faculty of Law, University of Colombo. For over 4 weeks through 7 series, we featured eminent personalities who reached their heights in law and other law-related professions. Our objective was to share the experience and expertise while you are at the comfort of your home, expanding your horizons, widening your knowledge, heightening your courage, and having no fear to enter the profession. This is Profession. Wake the professional in you. Right. So we have featured eminent practitioners in both official bar and unofficial bar and even different spheres of law. Today, we have a very special, very unique character which would take the session, the most valuable session of this Profession webinar series. Is none other than Honourable Justice Yasantha Kodagoda, President's Counsel. He was the Additional Solicitor General of Attorney General's Department, and he was the President of the Court of Appeal and currently sitting Judge of the Supreme Court. Your Lordship's lecture will be on advocacy in litigation, a guide for young lawyers and law students. Your Lordship, now the forum is over to you, sir.
Thank you, Charita. Good afternoon to you, ladies and gentlemen. The topic of this presentation is advocacy, with particular emphasis on advocacy in litigation. Litigation is basically the technical term for a court case. So we will be discussing this evening some general principles, and I wish to present to you some general guidelines on being a good advocate, how to engage in trial advocacy, and how to do well in your court appearances. Let me put on the presentation. Can I know whether all of you see the cover slide?
Your Lordship, we can see the slides.
Okay. If at some point of time, Charit, you observe that something is going wrong, technically, do let me know.
Certainly, Your Lordship, I will do the needful.
So, ladies and gentlemen, what we propose to do is to present to you a guide, something that you can use as guidance in years to come. The purpose of developing yourself professionally as competent counsel in courts of law. I must also say that becoming a competent counsel in a court of law is not the only area of activity that you may want to engage in. There are multiple fields of activity which lawyers can engage in. Functioning as a counsel is only one such area of activity. So we shouldn't go home entertaining the view that being a counsel is the only professional activity that an attorney at law can engage in. In fact, associated with court practice is another area of practice, and that is referred to as being an instructing attorney. Basically, those who appear in court are twofold: counsel proper and instructing attorneys. Technically, in terms of the Civil Procedure Code, the latter group is referred to as registered attorneys as well. They are basically the the link between clients and counsel, a very, very important area of professional activity. And of course, in addition to being either a counsel or an instructing attorney, there are plenty of other activities which attorneys at law can engage in, very rewarding professional activities. And I think as those who wish to enter the profession and as those who have just now entered the profession, it's important for you to uh, keep your eyes open and look at those multiple fields of activity that you can engage in. I say this because um, you may feel disheartened. Uh, you may feel disheartened by the fact that you can't develop a good private practice, or that you can't join the Attorney General's department as a state counsel. Don't feel disheartened, because appearing in court either as counsel or as an instructing attorney is only two separate professional areas of activity. There are plenty of other things that qualified attorneys at law can engage in. In fact, some are as rewarding as being a counsel. There is this technical term that you see here in the title, and that is litigation. Litigation is a technical term that we use for court cases. Litigation is a process, it's a legally regulated process relating to the hearing of court cases. So, what is advocacy? What do you think advocacy is? As I see, advocacy is a communication related process aimed at converting the thinking of another person. Your objective in advocacy is to convert the thinking of the other person to whom advocacy is aimed at, so that that other person at the end of this process of advocacy will start thinking the way you would want that person to think. That person will decide in the manner you would want that person to decide. And finally, he will act the way you would want him to act. That, ladies and gentlemen, is what advocacy is all about. It's a process. It's a process that involves communication. We will look at communication shortly. So it's a process. It's not a quick thing. It's a process. There are steps. It involves communication. And what is the objective? The objective is to get that other person to whom you're focusing your advocacy on to think, decide, and act in the manner you would want that person to think, decide, and act. Now, when you're focusing your advocacy on your target, the target of advocacy, you need to be mindful that at the time you start advocacy, his mindset can be primarily twofold. Either neutral, he has no stand on the matter, he's neutral, or he's negative. He starts with a view that opposes your view. So advocacy is aimed at converting that neutral minded person to your stand or that negative-minded person to your stand. I need not say, I assume, that what would be more challenging is not to convert the neutral into positive, but the negative into positive. So you need to, I think, keep that in mind. So you go before a judge. He might be either neutral or, due to multiple reasons, having read the brief in advance and due to various other reasons, he may have a negative view, an opposing view to your view. So converting that type of person to your line of thinking would be a great challenge. So you need to be conscious of course, he may be already with you in mind. He may have, having looked at the brief, having discussed the matter with another colleague, a judge, he may have already taken your side. That is unlikely, but that is also possible. Then, of course, no amount of advocacy is required. So, how do people get convinced? This process of converting requires what? Convincing the other person. Until he is convinced, he is not going to think, decide, or act in the manner you would want that person to. So it requires you to convince that person that your position is the correct position. That's I think important. So as I said, it's a process which involves communication, and basically in a court case, what is it that you do in substance? You're espousing or you're supporting the cause of your client. That is what you as a lawyer would do in a court of law. You will espouse, you will support, you will speak on your client's behalf and convince the judge that your position, which is your client's position, is the correct position. Now, as I said, advocacy involves communication. Now, what might be the difference between communication and speaking? What do you think the difference is between communication and speaking? Speaking is one way. I speak, you listen. You speak, I listen. That is speaking. You write and give me something, I read it. That's also one way. But in a court of law, in advocacy, it's not one way. It's communication. And communication, yes, involves speaking or writing by the person who is engaged in advocacy, but it's not one way. You address court, you write and tender written submissions, you make oral submissions. The judge does not remain passive. He may ask questions. He may comment. He may not verbally do something, but there may be gestures on his part. You will read his body language and you will continue to either speak or change your line of argument. So advocacy involves not one-way dissemination of knowledge or views. It's two ways. It's communication, and I think it is absolutely essential for you to be conscious of that. Advocacy is two-way. It's a two-way process. The judge may remain very passive, but possibly even unwittingly to the judge, he may indicate his mind by either asking questions or making various comments from the bench, or through his body language. So a good advocate, while focusing on what he says in court, he is conscious of the need to pick up from what is being said or done from the bench. And that's very important, to be able to read the mind of the judge. That is of critical importance, I would think. So good advocates, they have mastered it. They know to read the mind of the judge by a very simple, innocuous question that is asked from the bench, or by some sundry comment that is made by the judge, or by merely observing his body language. So I think, and that is not a skill that can be developed overnight. That is not a skill that is required only for court work. It is a skill that you would require in your general life as well. Being able to read the mind of the judge or the other person. Now, there is a link between advocacy and how we were used to be called. Up until 1973, all members of the legal profession were referred to either as advocates or as proctors. Advocates used to be the people who spoke in court, the equivalent to counsel today. And proctors were primarily instructing attorneys. They did appear in the magistrates' court also, off and on, but primarily appearing in court and engaging in advocacy was the job of advocates. The others were proctors, the equivalent of instructing attorneys. In 1973, the two-branch profession was fused by the administration of justice law, and since then, everybody who takes oath is referred to as attorneys at law. So the term advocate has been derived from the term advocacy. Those who engage in advocacy were referred to as advocates up until 1973. In the English legal system, the equivalent would be barristers and solicitors. Barristers would be in par with our former advocates. So in Britain, to a great extent, but not fully, to a great extent, the two professions are being maintained. Of course, the gap between barristers and solicitors is becoming narrow by the year, so to say. Now, as I said earlier, what happens in court is a technical process referred to as litigation, may it be in the Supreme Court, the Court of Appeal, the High Court, District Court, or the Magistrates Court. The process of court cases is referred to as litigation. We take matters before a court of law because there is an underlying dispute. Now, disputes can be resolved in multiple ways. One such way is a technical process referred to as adjudication. And that is what happens in a court of law. So, disputants may be private individuals, corporate entities, the state, companies, etc. Various disputants engage in litigation for the process of having their dispute adjudicated by a court of law. Disputants participate in litigation for the purpose of getting their dispute adjudicated by a judge. You must be already knowing that there are other ways in which disputes can be resolved, and the other methods are negotiation, mediation, conciliation, arbitration, and contractual adjudication. We don't have time to discuss those alternate ways. Because what lawyers participate in court is referred to as litigation, lawyers are also referred to as litigators. Lawyers who appear in court, both counsel as well as instructing attorneys, are referred to as litigators. It's important, though we talk about advocacy in the context of what happens in court, it's important for you to note that advocacy happens elsewhere as well. Advocacy happens, in fact, everywhere human beings are. Look at politicians. Consider the role of diplomats. Look at lobbyists, marketers, journalists, social reformers. All of them engage in advocacy. Take a normal TV commercial. What happens there? We are shown some milk powder, some very handsome, pretty people, very healthy looking people drinking a particular milk. And what happens? The next day we go to the supermarket, we decide to buy that particular brand. We see nice advertisements with people wearing a particular brand of spectacles. We thereafter go in for that brand. So those who design advertisements, commercials, what are they doing? They are engaged in advocacy. Politicians in public rallies, in TV programs, talk shows, in pamphlets, etc., they advance the various views, and we finally decide to pick on a particular view that is being expressed by a particular politician, or we decide to vote for a particular politician. So they are also engaged in advocacy. Social reformers, you have non-political social reformers, they also engage in advocacy. You get various non-governmental, voluntary or social organizations, civil society organizations on human rights, environment, animal rights, poverty alleviation. They engage in numerous activities aimed at convincing us that their line of thinking is correct, and thereby they persuade us to do various things. So they are also engaged in advocacy. While we are, as lawyers, we focus a lot on advocacy in courts of law, it is important to note that advocacy happens everywhere, including in our daily life. For those of you who are still under parental control, when you want to go out with friends, what do? You try to, you do various things. You say that you are going out with so and so, that he or she is a very nice person, comes from a comparable social background, that that person will never allow you to do anything wrong, etc. What are you doing? You're convincing the mind of your parents to get them to give you permission to go out. So in fact, you're engaging in advocacy. Hmm? So advocacy, while we as lawyers, we are focusing on advocacy in courts of law, there are numerous other people, including just laymen, ordinary people, who engage in advocacy, possibly not even knowing what they are doing. So, ladies and gentlemen, mm, why should lawyers or counsel engage in advocacy? To be successful in espousing the cause of your client, may it be the state or a private company or a private individual or an organization, um, you have to obviously act in the best interest of your client, and you have to achieve a particular goal in court of law. You, to be able to achieve that goal, you must get the judge or the jury to, as I said earlier, think, decide, and act the way you want to, because that will be in the best interest of your client. And this process, as I said, involves convincing, and to convince somebody, you need to engage in advocacy. Um, but having said that, I must also tell you at the very outset that while it is necessary for all lawyers to act in the best interest of their clients, um, you cannot overlook the fact that every lawyer, may it be a private practitioner or a state counsel, every lawyer has an overarching duty of supporting the cause of due administration of justice, to support the cause of due administration of justice. Before you become counsel for a particular client, you become an officer of court. You become an officer of court, and therefore, your primary duty, and this is, please don't forget this, your primary duty is to serve the court, to assist or support the court to correctly administer justice. Your duty to look after the best interest of your client is secondary to that. Please bear that in mind. Why is it that we discuss advocacy? Why is it so important for us to discuss about advocacy? And that is because it is through effective advocacy that you can win your case. It is as simple as that. To win your case, you have to necessarily engage in effective advocacy. So, if advocacy is the art of convincing the other, may it be the judge or the jury, you need to be conscious or aware as to the factors based upon which a judge or a jury becomes convinced. You make your submissions, or you present evidence, or you do both. The judge can become convinced. Judge may not be convinced. Judge may even decide to reject your position. If the judge becomes convinced, you will win. If the judge is not convinced, you may not win. If the judge decides to reject your position, you will certainly lose. So you obviously need to know the factors that will contribute towards the judge deciding either to accept your position or remain 50-50 without deciding either way, or the judge deciding to reject your position altogether. It's so very important for you to know what those factors are. These factors, ladies and gentlemen, can be broadly divided into two groups. The factors that will contribute towards the judge either becoming convinced or not convinced, or convinced that your position should be rejected. So these are three positions. These factors can be broadly divided into two groups, and they are external factors and internal factors. Let us see what external factors are. The judge or the jury may have prior knowledge about your case. How does a judge or jury acquire prior knowledge? Before the case starts? Through word of mouth, through media reports. So the judge can have prior knowledge. He may have his own inherent attitudes about people and about matters. He will also have his own experiences about men and matters. These things will invariably have an impact on the judge or the jury's decision-making process. Theoretically speaking, no. Theoretically speaking, these external factors should not have any bearing whatsoever. But you're going to address not a computer, but a human being. Or in a jury trial, 7 human beings. So you need to be conscious that there can be these external factors that have a bearing. Then, external influences. Now, a independent judiciary should really not have any external influences. Nobody should influence the judiciary. But there can be external factors that can have a bearing on the independence, the impartiality, and the neutrality of the judge. This is not to be expected from judges, but you need to be conscious that there can be external factors of this nature. What are the internal factors? Baseline knowledge of the law. So before you open your case, before you start making submissions on the law, the judge will have a particular knowledge of the law. He will import his professional and personal experiences. He may have heard a similar case in the past. He may have read judgments relating to certain factual scenarios similar to your case. The judge will be of a particular level of competence to adjudicate, to decide the case. He'll have a particular level of competence. And that level of competence between one judge to another would vary. Then as you start presenting evidence, he will start assimilating or absorbing that. And the power of absorption, the nature of absorption, the speed of absorption would vary from judge to judge. What is the type of evidence the law permits you to present? Testimony of witnesses, either orally presented or through affidavits, documentary evidence, contemporaneous audiovisual evidence like CCTV footage, computer evidence, and physical items of evidence. This is also referred to as real evidence, like, say, in a case of murder, the murder weapon, in a case of theft, the robbed items of jewelry, things like that. So this is important. The type of evidence you will present to convince the judge would be oral evidence, affidavit evidence, documentary evidence, contemporaneous audiovisual recordings, computer evidence, and physical evidence. Those are the main categories of evidence that you will present. So assimilation of absorbing and appreciating the evidence that is being presented would be a key factor. The understanding of the judge relating to the applicable law would be important. Earlier, we spoke of the baseline knowledge of the law. Now we are looking at applying the relevant law to the evidence in the case. And what is the relevant law? It can be the written law, like the contents of an act or an ordinance, judicial precedents, and that is binding previous judgments of superior courts, and common law legal principles. Take, for example, Audi Alteram Partem. Common law legal principles. Judges as well as jurors have certain tendencies and stereotypes. You would know what a tendency is. A tendency to disbelieve a particular type of witness. Stereotyping of witnesses. Some judges are of the view that certain categories of law enforcement officers, they just lie. So there are tendencies are very subjective. Stereotypes are also subjective. Then this is critical. The judge will have his own perception of you, of the advocate. This is actually not something that should be part of objective decision making, but invariably the judge is also a human being. The judge will have a particular perception about either through previous experience or through as a result of information that has trickled in through the grapevine. Hmm. Um, Advocates have uh, varying reputations about even matters that can have a bearing on even professional integrity. So perceptions of the advocate also has a role to play. Then, of course, the judge's very rational and objective decision-making process. It's a cognitive thing, what happens inside the brain. He will look at the applicable law, he will look at the evidence, he will arrive at findings regarding the credibility and the testimonial trustworthiness of the witnesses. He will look at the ingredients, in a criminal case, the ingredients of the offense, in a civil case, the ingredients of the relevant cause of action. He will apply the evidence into those legal principles and arrive at a decision. So it's a very objective, analytical approach, and that has a bearing. And finally, though I have listed it as the last item, the most important, the degree of convincing as a result of skills of advocacy exercised by counsel. How convincing were you? How convincing were you? And I think that becomes the most important factor in convincing a judge. Can I ask the moderator to inquire from the participants whether they would want to ask any questions?
Your Lordship, certainly. This is the advocacy in litigation, a presentation done by Your Lordship, Yasantha Kodagoda, President's Counsel. So our Lordship prefer that participant, if anyone willing to ask questions through the raise hand option, they can inquire from me so that I can proceed the question to Your Lordship. Your Lordship, I informed the participants. So if there are any questions, I can forward it to you, Lordship.
So at this stage itself, is there anybody who would want to ask questions or comment or share a particular idea or experience?
With the silence, it seems there are no questions, Your Lordship.
So we can proceed and maybe come back. Yes?
Your Lordship, there's a question from one of the participants.
Yes.
Shall I read it to you, Your Lordship?
Or you can ask the relevant participant to come online and.
Certainly, Your Lordship. For the moment, there's a question from one of the participants. What can be done to improve the communication?
In fact, it's very good to raise that question. I'm going to touch on it. The core component of communication is language. The core component of communication is the language. A mere working knowledge of the chosen language would not be sufficient. You must necessarily be fluent, and that is the expected standard. So language proficiency, I think, is about 75% of effective communication. Ability to conceptualize what you say, ability to portray what you say and present it while being conscious of either verbal or non-verbal feedback that you get from the target audience, I think is very important. Communication does not mean merely reading A to Z. Certainly not. in life, particularly through access to media, uh, you would have automatically identified effective communicators. If I am to share a personal experience, um, one of the most effective communicators I have come across is one-time Minister of Foreign Affairs, the late President's Counsel Lakshman Kadiraga. He had mastered the English language. He was not born an Englishman, so he had to learn English. He had mastered the English language. He kept on sharpening his ability to communicate in English. He used to strategize, conceptualize and strategize what he was going to say. He spoke with great clarity. He pitched the frequency of what he was saying to meet the target audience. I wonder whether you've seen that 1 minute YouTube clip of his speech at the Oxford University when he was invited to declare open his own portrait. He spoke for just 2 minutes. Just YouTube that, you'll get it. He ends up by saying that the cake was baked at home. He was an absolutely effective communicator. So my own path was by being very, very acutely conscious of the need to be an effective communicator, either verbally or in writing. I had role models. One was a personal family member, my late father. The other was Mr. Lakshman Kadiragama, several senior lawyers as well. So whenever I had the occasion to listen to them speaking or watch them addressing, I used to be absolutely glued to that target. Attentive listening, not mere passive listening and watching, 100% focused. And I used to emulate them. And I think that has helped me quite a lot. And I think as lawyers, you need to be fluent in more than one language. So either Sinhala and English or Tamil and English. To proficiency in 2 languages, I think is absolutely essential. And I don't personally believe in this philosophy all called not of the English language would suffice, or Singlish would be okay. I don't take that. You either speak Sinhala properly or you speak English properly. So being a master of that particular language, I think is important, that it is critical. Of course, there are certain other aspects to communication as well, and some of which we will be touching on during the course of this presentation. Any more questions?
If there are any questions, you can proceed the questions to our Lordship so that you can have the answers with our Lordship's experiences as well. Yes, Naminder, Your Lordship, there's one more question. Yes, Naminder, you can ask the questions from Your Lordship.
Yeah, Your Lordship, I have a question. Your Lordship mentioned about knowing the nature of the judge. Your Lordship, is it similar to the phrase, know your judge?
I would think so. I would think so. Competent and experienced counsel have developed profiles per each judge. Some judges, they would say, have a pro-state orientation. Some would say they have an opposite orientation. They would say some judges are rights-oriented. Some judges in criminal matters are very, very strict and pro-prosecution. Some are very, very humane, and they tend to treat people very leniently. So those are various tendencies of judges. Some judges, unless there is overwhelming corroboration, some judges will not believe the testimony of police officers. So we as human beings, we have our own tendencies, just like you all have. And I think being conscious of those tendencies, I think, is of crucial importance, because that helps you to communicate properly in a fitting manner. Shall we move on, Malik?
Yes, Your Lordship, we can proceed.
And in the meantime, if there are other questions that come your way, you can let me know.
Certainly, Your Lordship, I will do the needful.
So what are the aspects that a counsel should be concerned about? I think to start with, you must necessarily be concerned about your appearance. Yes, the dress is important. How you groom yourself is equally important. But I'm not only referring to your dress and how you have groomed yourself. Your external appearance, not only in professional life, not only at court, not only at, say, parties of lawyers, but even in your personal life. Advocacy, success or otherwise of advocacy, is to a very great extent dependent upon the perception the judge has about the advocate. And in that regard, external appearance matters. How you generally behave, how you conduct yourself, whether you are seen as either a gentleman or a lady, or a ruffian or a rogue, I think has a lot of bearing. You need to be conscious about that. The degree of confidence that you display in court has a bearing on whether or not the judge would get convinced by what you say. If you're shaky, if you show confidence, the judge is unlikely to repose confidence in what you say. If the judge sees you being unsure about what you yourself is saying, he is not likely to have confidence. So confidence is important. How you overall manage the case, you must have control over the proceedings, which you exercise in a very subtle way without trespassing into the discretionary authority of the judge. At least insofar as your witnesses are concerned, you must have control over their testimony. You must have control over the productions that are being exhibited. So overall management of the case has a bearing. Interactions with the judge, absolutely crucial. How you answer queries by court. your overall disposition towards the judge is important. So interactions with the judge plays a critical role. Your interactions with your opposing counsel is important. How professionally you deal with your opponent. He may try to bulldoze you. He may try to attack you in an inappropriate manner. He might make nasty comments. He might not be the gentleman you would want him to be. Nevertheless, you will not descend to his level. You will respond, but you will respond in a fitting, gentlemanly manner. So your interactions with your opposing counsel has a huge impact on the judge's perception about you. Then the pleadings, the documentary part of a case. In a civil case, it will be the plaint, the answer, and the replication. In a criminal case, it will be the indictment. These are the basic pleadings. In the Court of Appeal and the Supreme Court, it will be the petition and affidavits as well as attachments, or the statement of objections, affidavits, and attachments. Those are the basic pleadings. The status of those documents speaks volumes about your case. So the manner in which you have prepared them, their physical appearance, they are all crucial. Presentation of evidence, and let us for a moment reflect on the categories of evidence: oral evidence, affidavit evidence, documentary evidence, contemporaneous audiovisual recordings, computer evidence, and physical items of evidence, also referred to as real evidence. So you have 6 categories of evidence. How you present them is crucial. Your oral submissions, and we'll come to that later, and your written submissions. I have added one more point, and that is advocacy out of court relating to your case. Lawyers have this habit of discussing what happened in court, discussing your case with various other people. Some in fact come out and address the media, and I don't necessarily object to that. I don't necessarily condemn that. That's a new phenomena, and that is not uniquely found in Sri Lanka. In other countries too, the media up to the counsel and in key cases. So that's not. I wouldn't say that is inappropriate if that situation is being properly handled. I wouldn't say that it is counterproductive either. But what you say, how you say, is very important, because a judge does not stop listening and watching as soon as he leaves court. The judge will be attentive to what's happening in his environment. He will be attentive to media reports out of court. So you everything that you do out of court can end up in the ears of the judge. So you need to be conscious about that. What you discuss in the lawyer's canteen might reach the judge. So some lawyers are very careful. They will just simply not discuss the case outside court. If at all, they will get back to the chamber and discuss the matter with their immediate juniors, and that's it. But some others are not so disciplined. They discuss the case outside court. And what they discuss sometimes can reach the ears of the judge. So I think it's necessary for you to be conscious of that. Let us look at various components of advocacy. And as I said earlier, I'm merely repeating myself, communication skills is absolutely key. And the most critical part in communication is the ability to use the language in which communication takes place. So fluency. Nothing short of fluency would be the acceptable standard. Please bear that in mind. And as I said earlier, every lawyer must necessarily know, ideally 3 languages in Sri Lanka, but certainly 2. English and your own mother tongue, the vernacular. To present your evidence properly, to make a good submission in court, you must know the facts thoroughly. We sometimes see, and we lament when we see lawyers addressing court while reading from the brief. That is wholly inappropriate. That shows just one thing, and one thing alone, that the relevant lawyer is not thorough with the facts. Yes, you can certainly have your short note on a flipboard, and you can certainly address court while looking at it. But you're not going to read off the brief. Somebody who reads off the brief has not mastered the facts. And that is not a good sign for an advocate. When you're engaged in advocacy, I would suggest that you pay special attention to you have 2 witnesses. You have 2 witnesses. Witnesses of your side and witnesses of the opposing side. You need to portray that your witnesses are credible and trustworthy persons. You need to present their evidence fully. Similarly, insofar as your opposing witnesses are concerned, you should try to impeach their credibility. And that is through cross-examination. There are also occasions where you can, clever enough, extract evidence in your favor, even from opposing witnesses. You can extract items of evidence in your favor, even from opposing witnesses. So that's all to do with examination in chief and re-examination of your witnesses, cross-examination of opposing witnesses. Then a little bit about submissions that you make in court. Your submissions would relate to the applicable law, common law principles, as well as judicial precedents. Your submissions would relate to various comments that you're going to make regarding your own case, as well as the opponent's case, in most instances using logical reasoning, logical reasoning. And your submissions will also relate to how bad, in your opinion, the opponent's case is. So you will basically portray your case to be the truth and portray the opponent's case as not being truthful and not being compatible with the applicable law. And using this, you will develop arguments. So please remember that advocacy is not about merely making a statement about the facts. That is, you don't need an advocate for that. You can get anybody, you can get the litigant himself to read out the facts. Advocacy doesn't mean mere presentation of facts. Advocacy is a combination of these things aimed at convincing the judge or the jury, as I said earlier, three things: to think, to decide, and to act in the way you would want them to think, decide, and act. Advocacy, ladies and gentlemen, should be strategic. You develop what you're going to say and what you're going to do based on a strategy aimed at convincing the judge or the jury. So as I said earlier, it is not merely narrating the law. It is not merely narrating the evidence of the case. It's much more than that. Clarity is absolutely essential. So you can't be confused when you're addressing court. You should never confuse the judge. So clarity is of critical importance. And you must not digress from your goal of advocacy. What is the goal of advocacy? The goal of advocacy is to convince the judge that your position is the correct position. So to engage in effective advocacy, you must conceptualize a particular plan and implement it strategically. So what are you going to, when you're conceptualizing your strategic plan for advocacy, what are you going to focus on? If you are going to strategize on what to say and what not to, and how to say, and the sequence of saying it, what is it that you will have in mind? You will carefully consider what in which sequence would result in the judge or the jury becoming convinced. And remember, other than in very few ex parte cases, you will always be confronted with an opponent. So you're not the sole actor in a court of law. You and your opponent to be seen and heard by the judge and or the jury. So effective strategization requires you to not only conceptualize your plan of action, but to conceptualize your opponent's possible plan of action as well. Your opponent's possible plan of action as well. And be ready to counter your opponent's plan of action. So you need to think in advance. You need to think in advance as to what your opponent's plan of action is likely to be. And you have to prepare in advance to counter his points as well. So you use logical reasoning to show the fallacy of the opponent's submissions, the improbability of the opponent's position. You'll have a lot of preparation that is required to strategize how you're going to counter the opponent's point of view. Are there questions?
Participants, if there are any questions, your lordship expects questions from you. So you can raise your hand and just ask any question with regard to the presentation. Your lordship, we have a question. Shanal Vijay Singha.
Your Lordship, I have a question. Your Lordship, what are some things that you would advise a young lawyer and a law student not to do?
In fact, I've identified a few points in the presentation itself. Off the cuff, never ever offend the judge. Never ever offend the judge. So not to do. Never offend the judge. That is absolutely essential. Never treat the opposing counsel in a degrading manner. Never treat the opposing counsel in a degrading manner. Never start a case unless and until you're ready. Never start a case prematurely. Never try to convince the judge of something that you're not convinced with. It becomes so apparent from the bench. If you're not convinced and you're trying to convince the judge, it becomes so very apparent after some time in particular. So these are some of the never to do things. We'll look at some of these things in greater detail as we proceed.
Thank you, Your Lordship.
Any more questions?
Any more questions with regard to the presentation, participants?
Shall we proceed?
Yes, Your Lordship, we can proceed.
So, as I said earlier, never start a case unless you're absolutely ready. Therefore, on the trial date, you must be ready to commence and to continue with the case. So, a lot of preparation in advance. Be ready to start the case on the scheduled date. And starting the case on the scheduled date does not mean that you start the case and after leading the evidence of the first witness, you ask for an adjournment. Once you start a case, you must be ready to continue with it until whatever time the judge wants to take an adjournment. Until whatever time the judge wants to take an adjournment. So that shows that you must put in a lot of preparation. The opposite of this is also very important. Due to multiple reasons, on a particular day, the judge may not be ready to take up your case. If so, do not push that the judge takes up your case. Read his body language, interpret whatever he says, and see whether he is ready to take up the case. If he is not, you will not achieve anything by pressing him to take up the case. Just get a postponement and come back the next day. On the other hand, as I said earlier, if you feel that the judge is interested in taking up the case, respond positively and get the case taken up. This is a difficult situation. You may have reasons to believe that a particular judge should not hear your case for multiple reasons. And sometimes your own client might come and say that a particular judge should not hear the case. So this is a very sensitive and a tricky area. First, see whether acting on his own motion, the judge is going to recuse himself. If not, ask yourself whether there is a well-founded reason as to why this particular judge should not hear the case. Clients might come out, tell you various things about the judge, but you must look for proof. You must see whether the apprehension on the part of your client is well-founded. And if so, it is advisable that you take up the issue with the judge, not in open court, but in chambers. You take it up in chambers and explain your concern. In all probability, I would say, it is likely that the judge would recuse himself after you explain matters. But if not, you have the most unpleasant task then of raising it up again in open court and requesting the judge to recuse himself and have it recorded as well. This is a very exceptional situation. It's not a common occurrence, but I thought it is necessary to place that point before you. If at some point of time you see now the case has started and it's going on, if you feel that the judge is either distracted due to multiple reasons, or is feeling sleepy or tired, and doesn't want to continue the case, it is best that you take the initiative and ask for an adjournment. Don't wait until the judge takes the initiative of postponing the case. If you feel that he is either not in a mood, or he's tired, sleepy, or he's distracted, identify that and be the first to move for an adjournment. The next point is also very important, particularly when two adults of two different protocol systems interact. There can be a stage where one tries to reign supreme over the other. It's called a personality battle. Never engage in a personality battle with the judge. Never ever threaten his superiority. And in this regard, I must say even things like eye contact matters. How you conduct yourself towards the judge, how you address the court, how you respond to the judge is important. So don't leave room for the judge to feel threatened by you. So you must always be absolutely respectful, courteous, and even humble towards the judge. And I'm not for a moment saying that you need to be subservient to the judge. Certainly not. Maintain your status, maintain your standing, maintain your dignity, maintain the entitlement of your client to be represented by a straightforward and a competent lawyer who is independent. But you must be respectful, courteous, and humble towards the bench. And therefore, never ever attack or ridicule the judge. That is inappropriate, that is unethical, and it is counterproductive. Even with regard to the opponent, you will come across multiple personalities as your opponents. Some have the tendency of being nasty to the opponent. Some wants to reign supreme and they try to bulldoze the opponent. Some are very, very difficult people to get on. But you must know to maintain your standard, professional ethics as well, and not to engage in personal battles with opposing counsel, personality clashes as well. You don't have to, if he conducts himself in an inappropriate manner towards you, I don't think you should resort to his ways of attacking you. Your link is with court and not with your opponent. So handle your opponent in a fitting manner. Technically speaking, you are required to satisfy yourself when a case comes up before court that, particularly if you were not the party that filed the case, say in a civil case you appear for the defendant, or in a writ matter you appear for respondents, you must, satisfy yourself that the court has jurisdiction to hear the case. Otherwise, technically, you must raise a preliminary objection relating to jurisdiction of court. But from a human perspective, something that judges don't like to hear is that they don't have legal authority to hear a particular case. So I would suggest that you should raise an objection regarding jurisdiction of court only if, and I repeat, only if there is no other alternative. So unless it is imperative, don't raise a preliminary objection regarding jurisdiction. Other preliminary objections too, say the petition is out of time, the claim is prescribed, or technical necessities relating to the filing of the case have not been satisfied, things like that. Some are very good at raising preliminary objections. From a judge's perspective, most judges are very reluctant to throw out a case on preliminary objections. They feel that when a case is filed, they must look at the merits of the case as well. So unless it is absolutely essential, don't raise preliminary objections regarding the maintainability of the action, unless, of course, it is absolutely essential. Or what you can do is to very briefly raise the preliminary objection and tell court that you will deal with it more fully when you're addressing court properly, when the merits of the matter are being gone into. And that is because some judges believe that preliminary objections are raised only when the other party has nothing to say about the merits. So that can operate against you. So be conscious of that. Always, if this is a type of case where you will be presenting witness testimony, I suggest that you start the case with a star witness, or if it is through legal submissions, start your submissions by presenting a very formidable, a strong point to start with. During your submissions, I think it is not a good style to keep on laboring on the same point over and over and over again. You have to move on. Sometimes on policy matters, there can be a brief encounter with the judge. On various ideological matters, there can be a difference of opinion. I think it is best to avoid confrontations with the judge. Maybe even on the law, the judge can have one point of view, you can have another point of view. You will present your point of view and just stop at that. There is hardly anything that you will gain by engaging in a confrontation, a verbal fight with the judge. At some point of time, if you observe absence of focus, absence of attention by the judge, as I said earlier, for multiple reasons, maybe he's tired, maybe he has some urgent matter, personal matter to attend to, maybe he's distracted due to various reasons, he may be feeling even sleepy. So at some point of time, if you feel that the judge is losing focus on your case, without any delay, move for an adjournment. You take the initiative and move for an adjournment. Due to various forms of conduct by the judge, you might get angry or you might feel annoyed. Ideally, don't get angry with the judge. It doesn't help you. But even if you do get angry, don't show your anger towards the judge. It is not good for that interpersonal relationship between both of you. It is not good insofar as the judge's perception of you is concerned. Very, very competent lawyers, very experienced lawyers, generally accept the judge's point of view, even if they don't internally agree. They accept the judge's point of view, and later on, if they feel like, they will come back in a very subtle way, they'll come back to the same point and try to convince the judge. But upfront, they will not openly express disagreement. Particularly in original courts, I think you need to be conscious of the need to use the language the judge seems to be comfortable in. So you'll have to be conscious of that. Now, generally in appeals as well as revision applications, the core focus is on impugning or challenging a particular order of an original court or an inferior court, or a procedural step taken by an original court or an inferior court. That is the whole purpose of an appeal or a revision application, or even the final judgment for that matter. Now, when doing that, I think it is important not to personally attack the judge who made the relevant order or delivered the relevant judgment. Legally, forensically attack the impugned judgment or the relevant order or the relevant procedural step without attacking the person. I think that's crucial. And in appeals and revision applications, if you take any trial proceedings, any case for that matter, when you look at the brief with a fine-tooth comb, you will invariably be in a position to identify a procedural breach, or in an order, some technical error. Any brief, if you go through it from cover to cover, meticulously study it, there will be something that you can find fault with. However, appellate courts, superior courts, would decide to interfere with an order of original court only if they have formed the view that there has been a substantial miscarriage of justice. Just because there is some technical error, they will not interfere. Because for every technical error, minuscule type of error, if the appellate court starts interfering, there won't be any finality. So, particularly as superior court judges, we look for whether, in addition to this technical error, whether that technical error had resulted in a substantial miscarriage of justice. And we will be motivated to interfere only if there has been a substantial miscarriage of justice. And I think when you're picking holes, so to say, of relating to proceedings or a judgment or an order of original court, see whether you can develop a nexus between the impugned order or the procedural step and the final outcome, justice, and see whether this error had resulted in a substantial miscarriage of justice. We generally don't like to listen to inappropriately long submissions. It's tiring and it's counterproductive also at times. So don't make submissions unnecessarily lengthy. It is very attractive if you can end your submissions at a peak with the best possible point. Now, some people, they keep on addressing court, and they'll then, towards the tail end, they'll keep on changing, turning pages of their notebook, and finally end up saying, I have nothing else to say. That's not attractive. That's not appealing. You must stop at a peak. You start at a peak, you end at a peak. So keep good firepower to be used at the tail end also. Ideally, you must present post-argument written submissions. It's very important. It's very useful to the judge as well. So always at the end of oral submission, seek permission of court to present a post-argument written submission. That can be very useful. I think what you need to do with a judge hearing a case by himself, to consider the judge to be a single member jury. So basically, that's how you need to look at a judge sitting alone, as a single member jury, and try your best to convince the judge. I think it is important that you remember that advocacy is a skill that would require a lot of time for you to develop. Effective advocacy is a skill that requires developing over a long period of time. And in that regard, experience would really help. Learning from seniors would help. Practicing advocacy would help. I suggest this strategy. This is something that I used to do when I used to work for the Attorney General. I develop my case. I study the brief. I develop my advocacy. I make a note of it. I don't try to retain everything in my brain. So I make a note of it, my line of attack. I then take a new page and I start critiquing my own submission. I assume the role of my opponent to be, and from his perspective, I start attacking my argument. That helps me to reshape my submission wherever it is necessary. Another way of doing the same thing is to invite a professional colleague of yours to play the role of your opponent. So you get a friend to study the brief, listen to your submissions, and critique it as if he is your opponent. That's called playing the role of the devil's advocate. That helps. So, winding up, I would think that advocacy is something that all attorneys must necessarily develop and sharpen, irrespective of whether or not you're going to end up practicing law in a court of law. And remember that the best advocate does not necessarily win the case. And that's perfectly okay, so far as you've put on a good fight. So, what is more important is for you to support the judge, as I said at the very outset, to administer justice correctly as opposed to winning the case. Your key duty, your key responsibility is towards court to start with. Your duty towards your client is subordinate to your overarching duty to support the cause of justice. I must say, some of you are likely to become very good advocates, but don't use advocacy at the cost of ruining your professional and personal reputation. You must use advocacy only to support court to deliver justice, not to win bad cases where the law is against your client. And that is because, from a very broad national and social perspective, ensuring that justice is delivered is more important than being the best possible advocate or winning an otherwise bad case. When engaging in advocacy, never mislead the judge, never ever mislead the judge or the jury. never, and that's very serious, deceive the judge or the jury. It's important for you to remember that you all are, if you haven't taken notes already, you will be entering a noble profession. We, as all lawyers, I'm also a lawyer, though I'm a judge. We have to protect the reputation and the standing of the legal profession. You may appear for the state or for private parties or for corporate entities. Be that as it may, you remain to be officers of court whose primary duty is to assist court to administer justice. Yes, indeed, you have to act in the best interest of your client, but that is secondary. I think it is absolutely essential to protect your professional and personal reputation. To me, that is more important than winning a case. What is more important is to be a good advocate, put in your best effort, and await the outcome of the case. One party will win, but it is important to note that the judge and silent observers will also assess who out of the two lawyers was the better advocate. Even if your client loses, if you emerge to be the better advocate, I think that is a prize for yourself. And that is what will result in your professional reputation being enhanced and your practice of the law developing. Charit, I have come to the end of my presentation.
Yes, certainly, Your Lordship.
We have about 15 minutes left, and therefore I'm ready to take questions, if any.
Yes, certainly, Your Lordship. We have a question from one of the participants. Your Lordship, what are the best approaches for an advocate in the court to prove his integrity to the Honourable Justice to win his hearts and minds?
Well, I think winning the heart and the mind of the judge is something that will happen not immediately, but over a long period of time. Through what? Through being a true professional who knows the law, who is an effective communicator, who has mastered the facts, who has been sincere to court, and over a period of time remained consistently sincere. And that is how you earn a positive professional reputation for yourself.
Certainly, Your Lordship. There's another question. Your Lordship, if a law student has a dream to become a judge someday, what is the path that he or she needs to follow?
So there are primarily two in which you can become judicial officer. One is to become a career judge by starting the judicial career from the level of the magistracy, that is by becoming a magistrate. In terms of the existing rules imposed by the Judicial Service Commission, which is the appointing authority, you have to put in a period of 6 years as a practitioner to be able to apply to the magistracy. There is thereafter an entrance exam and an interview. Once in about 2 years, approximately 10 to 15 magistrates are recruited. The number would vary and the intervening time period also may vary. So you start off as a magistrate you become a district judge, a high court judge, a judge of the Court of Appeal, and a judge of the Supreme Court. So that's one pathway. The second pathway is to continue to practice either in the unofficial bar or in the official bar and try to get appointed to the judiciary at a midpoint. Traditionally, there have been three midpoints. One is the level of the High Court. The other is the level of the Court of Appeal. And the third is the level of the Supreme Court. There have been few instances where members of the unofficial bar have got directly appointed as High Court judges, Court of Appeal judges, and Supreme Court judges. But the more popular or common way has been for senior officers of the Attorney General's Department to get appointed to the judiciary at these levels of the High Court, Court of Appeal, and the Supreme Court. So in my own case, I took oaths in October 1988. By the 1st of February 1989, that's just 3 months after taking oaths, I joined the Attorney General's Department as a state counsel. 10 years down the road, I became a senior state counsel in 1999. In 6 years afterwards, in 2005, I became a deputy solicitor general. In 2015, I became additional solicitor general. Same year, I was appointed the president's counsel. In 2019, I was appointed to the judiciary as the president of the Court of Appeal. And early this year, I was appointed a judge of the Supreme Court. Traditionally, appointing authorities have been looking at the Attorney General's Department for the purpose of selecting people to serve on the higher judicial. Sri Lanka has had 45 Chief Justices up to now, including the current Chief Justice, of whom over 35 have at some point of time worked at the Attorney General's Department. In the current composition of the Supreme Court, out of the enhanced cadre, which is now standing at 17, other than 4, all others, 13, have served the Attorney General's Department at some point of time or the other. So if you don't want to come through the traditional pathway by becoming first a magistrate and then moving upwards, the second option, so to say, is to join the Attorney General's Department as a state counsel and come up the ladder. And at some point of time, join the judiciary, the higher judiciary. I have obviously this bias towards that approach because that is the approach that I followed. I recommend the Attorney General's Department to any young lawyer who wants to become a good advocate due to a key reason that the Attorney General's Department is the only place, I would say, where a young lawyer gets to practice law by himself. You join the Attorney General's Department today, and within 1 month, you are sent either to the district court or to the high court to appear in cases. Obviously, you will be supervised, but you get the occasion to appear in cases on your own feet, not as junior to a senior counsel. So in a colloquial way, I would say, you get batting practice. You get plenty of batting practice. when you're at the Attorney General's Department. So whatever advocacy I was able to develop during 30 years before I joined the judiciary was wholly due to the exposure I got at the Attorney General's Department. So I would overwhelmingly recommend those of you who wants to become good advocates to join the Attorney General's Department, because that is the best place you can learn and get the opportunity to engage in advocacy by yourself. Of course, guided and supervised by senior officers of that department. It was a great privilege to serve that department for a period of 30 years. And whatever I have gained is totally due to the splendid opportunity I got to serve the Attorney General's Department. Absolutely wonderful place. So I would, most of the new people who are joining the profession, who want to become good advocates, I would suggest that they try to join the Attorney General's Department. Of course, traditionally, for a long period of time, officers of the Attorney General's Department, having put in 5, 10, or 15 years at the Attorney General's Department, have moved out and engaged in private practice since then. And overnight, they have developed good private practice. If you look at the huge array of leading private practitioners in this country, other than 1 or 2 leading counsel, a large number of them have at some point of time or the other served in the Attorney General's Department. Successive presidents of the Bar Association, large number of President's Counsel, eminent counsel who appear in the Supreme Court, not all, but a very large percentage of them have served the Attorney General's Department and at some point of time decided to quit public service and reverted to the unofficial bar. So from the perspective of developing a practice also, I would think serving the Attorney General's Department is a good thing or a wise thing to do.
Your Lordship, we have one more question. If at any point our client confess to us, should we as the lawyer inform the courts of such?
Well, if in a criminal case, if a client were to confess, firstly, I would say never try to extract a confession. People like Dr. Colvinda de Silva in multiple interviews have said, though they study the brief and get instructions from the client, they have never asked their client, did you commit this murder? Did you commit this wrongdoing? So never try to extract a confession. But if the client were to, on his own motion, confess that he committed the crime, one option that is available is for you to advise the client that he should, under those circumstances, plead guilty to the charge. And that what seems to be in his own interest is to give you instructions to make submissions to mitigate the sentence, to reduce the sentence. So that's possible. But you may come across a client who says, I committed the crime, but I want you to defend me. Let's go to trial. So then, of course, you are duty bound to defend him unless you return the brief with his consent. You have the entitlement of getting his consent and returning the brief. Of course, you'll have to return the fee also, having retained some amount of money for the consultation you had. I would, there have been times in my career where I had to give consideration as to whether I should revert to the private bar and practice. And one thing I told myself is that I would never be ready to engage in criminal defense work. I would certainly love to practice, but I would never be ready to engage in criminal defense practice. That is to appear for criminals, because of this. If I get to know that my client has in fact committed the crime, I would not feel confident at all to engage in advocacy for the purpose of securing his acquittal. It would be against my conscience. So it's of course very, very personal. It's a personal matter. Of course, there are plenty of other areas where continuing to appear for a person need not prick your conscience, say civil law or public law matters. That type of situation doesn't arise. Any further questions?
Yes, we can give the opportunity for a few more questions. Are there any questions from our participants to our Lordship?
So it seems that there aren't any more questions.
Yes, Your Lordship. Right. So today we had a wonderful session, the most important session it seems with the profession lecture series, the online discussion and webinar series on professional development and career guidance organized by the Pro Studies of Sri Lanka Law College, the profession in collaboration with Lead Generation of Faculty of Law, University of Colombo. On behalf of Lead Generation, Faculty of Law, University Colombo and Pro Studies with regard to profession, we all like to thank you all very much, the participants who join us with these sessions. And this marks the end of the webinar series on professional development and career guidance. More than 4 weeks, we had 8 sessions. So thank you all. Thank you very much. And today, with our session, we had Honourable Justice Yasantha Kodagoda, President's Counsel. So thank you very much, sir, for joining with us, Your Lordship. Indeed, it's a privilege for us to have such a personality like you, the expertise, experience that you have gained throughout your career as a senior citizen and a superior person to our life as well. Thank you very much, Your Lordship. Once again, we thank you all on behalf of the entire law students fraternity for joining us with profession. So we had 8 sessions, nearly more than 4 weeks. So hope you had expanded your horizons, widen your knowledge and heighten your courage and have no fear to enter the profession. Thank you all very much. So stay tuned for more activities of profession, pro studies and lead generation. Furthermore, with regard to the future perspectives. Thank you all. Thank you very much. Awake the professional in you.